We've been talking about case histories and some theoretical considerations in recent videos. Now it's time to return to some practicalities, what we might term basic maintenance and keeping things tidy. Earlier, there were a series of videos which dealt with the oath and the notices. There are 5 notices in all, and the last 4 are always the same in sequence. The first, however, has 2 types. One we covered was the notice of lawful objection, where we inform alleged Crown officials, such as police, court officials and councils, of our lawful standing under Article 61, explaining that we do so to forestall any future attempts at unlawful demands being placed upon us individually, which might of course give rise to breaches of the peace against us being committed by these would-be agents of government. The second, the notice of conditional acceptance, we are going to cover today, in conjunction with the admonition that it is very important to send out those notices of lawful objection to what we call the 3 Cs. These are the cops, the courts and the councils. The reason we do this is because eventually we are all going to be impacted by these unlawful demands, if indeed we are not being so impacted already. We're all familiar with traffic offences, most of which are so minor that a simple warning would be enough to amend most people's behaviour, but instead are clearly aimed at raising revenue. But what about council rates? Do you have a water and electricity bill? Or must pay the council a fee so that they don't come to steal and impound your pets? What if you have endured the pain of a divorce and someone you've never heard of writes to you that you must now pay a certain percentage of your income to the upkeep of your children of minor age, even though you may be prevented by circumstances or other forms of what we might term enemy action from having any reasonable access to them? Even though you may be quite willing to help sustain them financially if the arrangements were negotiated equitably, rather than being arbitrarily imposed by what turns out to be a series of for-profit corporations. Some may be asking how water and electricity bills are unlawful demands, when of course we all consume the relevant products. But consider the question, is water essential to life? The answer is yes. So why do we have to pay for something that we can't live without? Who owns all the water in our municipality? Isn't it the community as a whole? Doesn't everyone have an equal right to it? So how come it ended up in the hands of a for-profit corporation? Did they pay for it? And if so, to whom was the money paid for this public resource? Does anyone watching this video remember giving permission for their inalienable right to life-sustaining water being sold to someone so that they could make a profit from it? And what about the toxic chemicals like fluoride which they pour into it? I smell a crime. Does anyone else? If this is okay with water and power, what about air? Should we expect at some stage to be forced to wear an airtight helmet with remote cut-off switches and forced to pay for the air we breathe? Hopefully not. But what's the difference in principle? The fact is that there is an abundance of taxpayers' money spent to provide these essential services, and enough to maintain them as well. So why should some corporations and shareholders be given a license to profit from them, while everyone must pay and pay simply to sustain their lives? Is that equality before the law? Or should we not be placing these entities, or rather the criminals running them, on notice of our standing under Article 61 and our refusal to aid and abet them in committing treason? Remember, any act or statute, directive or mandate which abridges our inalienable constitutional rights is treason, and we are under instruction to assail this treasonous crown in, quote, whatever way we can to the utmost of our power until we have received redress as we deem fit, unquote. It gives us pause for thought, doesn't it? Thus, even if we do nothing wrong in our lives, we are going to be persecuted in these and many other ways by these criminal enforcement agencies. It's for this reason that we must place the 3 Cs on notice as soon as possible. Here is a diagram showing the basic outline of this strategy. This shows that we notify the CEO of the local council, the registrar of the local magistrates court, and the CEO of the chief magistrates court of our state, plus the senior officer of our local police station and the police commissioner of our state. All must receive all 5 of the notices, the first one being the notice of lawful objection. Then, if we are impacted by any of the arbitrary demands that emanate from any of the myriad of bureaucracies or agencies which beset us and hedge us about with their interminable rules and regulations, we can refer to the file we and they already have and remind them that they already know that what they are doing is wrong in law. We are on the front foot. We don't want to have our backs against the wall. They will still try to put us in that position, but we will be holding the cards and we can start asking the questions. And in any power struggle, the one asking the questions is in control. The first question we ask when we do receive an unlawful demand from these impostors is on the second page of the Australian version of the Notice of Conditional Acceptance, when we ask them, politely, to, quote, please provide evidence in substance to counter this claim within 10 days from your receipt of this Notice of Conditional Acceptance, and I shall comply with your demands in full, unquote. The claim to which we refer to is shown on page 1 of the notice, seen here. After the normal courtesies of names and addresses, etc., the first substantial paragraph outlines the declaration of our oath and the fact that we have transferred our allegiance away from the Crown while it remains treasonous towards the Constitution via the Committee of Barons, and indicates some of the evidence of the invocation of Article 61 which is to follow. Then there follows an explanation of treason committed by the Australian government since 1973, much of which is in lockstep with that of the British government. And this moves into a statement of irrefutable evidence that Article 61 was invoked and the fact that we are bound by it to refuse to comply with illicit demands, and also bound to compel anyone who is not abiding by what is now the law of the realm, including the recipient of our notice, to also abide by the law. They are then told in plain language that unless they can provide proof that Article 61 is not in effect or has been revoked, that it will be admitted that our statements are facts in law, and that any further attempts to extort money or make any other threats will constitute acts of high treason, which may well result in action taken against the recipient personally. Following that is the section where we sign and attach the names of our witnesses and the dates of their witnessing, which must obviously not be dated after the date of sending. In this example, we see the option, if we can't get 3 live witnesses together, of using the per procuration option, where we can sign our own name 3 times, writing in title case, which is capital first letter, lowercase subsequent letters, the names of those people who have given us permission to do so. There has been success recently in simply asking people in the post office or a public place to witness our signature. We are only asking them to witness us signing, not affirming anything in the document itself. There then follows a list of exhibits which we are submitting as evidence, the last of which is a copy of our oath, to which we attach a photocopy of the envelope in which we sent it and a copy of the registered post receipt. The evidences listed are applicable for any British Commonwealth country, but in Australia's case we have added some of the local treason evidence, which should make it clearer to our recipients that we are not referring only to some ancient historical document from a faraway country, but to the law that still governs us here. So, in summary, it is imperative for our own convenience and best chances of success that we place our 3 C's on notice, keeping copies of everything for future reference, for they will eventually try to hit us up either for money or compliance of some sort. At that point, we can rebut them with the Notice of Conditional Acceptance and the others again, which will have the added force of our previous notices buttressing them. I've listed just a few of the many unlawful demands which can be placed upon us, some of which are not immediately obvious, and some of which will carry greater risk of loss if we eventually decide to comply under duress. It's up to everyone to pick their battles and decide how far they want to hold the line, if their nerve fails them. It is not up to anyone else to judge such people because we are not living in their shoes. That is why we need to support each other to the nth degree. What happens, for example, if an agency starts garnishing the bank account of their victim, despite being warned that the person whose name is on the order or the demand will be personally liable? Are we prepared to help such a victim fight such a battle in law, or with personal help? These are things we need to consider in the times ahead. Thank you for watching.